vehicle, sale of marijuana, possession of marijuana with intent to distribute, theft by receiving a firearm, and possession of a weapon by a convicted felon contrary to the law. The state, good order, peace, dignity thereof. They're going to repeat, but Your Honor, my belief is that the grand jury, by and through the Fulton County District Attorney's Office, did not allege a material element. There are 4 material elements in violation of criminal street gang activity. And there's going to be a jury instruction that the court, one day is going to give to the jurors. There is a jury instruction on this crime. I'm trying to get you the pattern jury charge that gives the essential elements. And that would be pattern jury instruction 2.02.25. And there's also case law that one of the essential elements is that the crime was committed to further the interests of the gang. That is omitted in count numbers 56 and 57 for Mr. Williams. There are other people here charged, Your Honor, that has the same issue. Okay. But they're different count numbers. And the way I understand the law is that the fact that the statute does not give the mens rea, every crime has to have the mens rea attached to it, and that when the legislature or Congress does not include the mens rea, the courts say that the omission from a criminal statute of any mention of criminal intent should not be read to dispense with that essential element. This rule of construction reflects a basic foundational principle that wrongdoing must be conscious to be criminal. And here, and that was, I'm sorry, under MORISSETT versus United States. That's 342 U.S. 246 at 252, 1952. It's also explained in Elonis, ELONIS versus United States, 575 U.S. 723 at 734. It's a 2015 case in Division 2.
I'm sorry, 575 U.S.
723.
Okay.
At 734. It's a 2015 case.
Okay.
It's in Division 2B. And that specifically says that the fact that the statute does not specify any required essential element, including mental state, does not mean that one does not exist. And here what happened is there was a challenge years ago under Rodriguez from this courthouse, Georgia Supreme Court, said in order to save, or that it is a constitutional statute because it's not a denial of freedom of association, because you don't have the right to commit a crime in furtherance of the gang. Mm-hmm. That became an essential element. That changed our jury pattern instruction. Yeah. And our grand jury did not, in our case, did not allege that. Okay. So I know that there's a lot of argument about, well, this is a gang case, and then 418 kicks in, 24-4-418 kicks in. but I believe that the charges for the gang is not appropriate. I wrote.
And did you say, I'm sorry, did you say that, what did you say the Court of Appeals did?
They didn't take it up.
They didn't take it up, okay.
I didn't get under Dukes, D-U-K-E-S. I don't have, Judge Glanville denied a certificate.
Oh, okay.
They never
I thought you sought, but you did not secure a certificate. So then you took that up under the collateral order rule and.
Did not, they said it's not a collateral order. I
Okay.
needed a
All right.
certificate.
So they gave you an opinion on the merits of, is this a collateral order thing you can take up?
And
Okay.
then they dismissed the appeal. So there's no
Right.
rule of the case.
Okay.
So that is, a couple of counts for Mr. Williams. He has 6. Then the conspiracy, which we're talking about. Okay, I'm sorry.
So you said that with regard to counts 56 and 57, it is not alleged.
I promised that.
Okay. And are there other counts that are alleged against your client, Mr. Williams, where that is an issue?
Yes, there's an essential element in count 1.
Okay.
Which is the RICO count. And I compared it, I just did it because, it's such a well-known case, to the Donald Trump indictment out of the same grand jury courthouse.
Uh-huh.
Nowhere in count 1 will you see that any of these individuals have been charged with joining the conspiracy knowingly and willfully. It is not in there. And that's RICO conspiracy count starts, I think, at page 12, but hold on.
All right. And so you're saying nowhere in, I'll read it. It's pages 1 through 68 of the indictment. But no, I'm sorry, 12 through 68. You're saying nowhere in that 50-something pages does it allege any of this was to further the interest of the gang?
No. I'm saying that it's a different.
No, that's not what you're saying, or no, it's not in there.
I'm doing a different issue in count 1.
Okay.
RICO conspiracy.
All right.
The grand jurors charged that Mr. Williams and the others who were here, also the others who are not here, unlawfully conspired to acquire and maintain directly and indirectly an interest in and control of U.S. currency and other personal property through a pattern of racketeering activity in violation of OCGA 16-14-4A, as well as 4B, as well as B. But what happened there is, I went through it hard. There is no allegation by the grand jury that Mr. Williams or anybody knowingly and willfully joined the conspiracy. And under Cotman, which is C-O-T-M-A-N versus State, which is 342 Georgia Appeal, 569, it's in Division 2.
Okay.
The 2017 case. That is a teacher from the APS trial. It was also a RICO conspiracy case. The Court of Appeals of Georgia held that in order to commit a conspiracy under the RICO statute in Georgia requires proof of the material element that the accused knowingly and willfully joined the RICO conspiracy. That is also in MacArthur, which is M-C-A-R-T-H-U-R versus Beach, which is B-E-E-C-H. Haven, which is H-A-V-E-N Baptist, B-A-P-T-I-S-T Church of Athens. Your Honor, it's 368 Georgia Appeal, 525, it's in Division 3. 890 Southeast 2D, 427, that's a 2023 case. Cotman specifically wrote that under Georgia law, a person may be found guilty of the crime of RICO conspiracy if that person knowingly and willfully joined the conspiracy, which itself contained a common plan or purpose to commit 2 or more predicate acts. There's also Wiley, which is W-Y-L-I-E versus Denton, D-E-N-T-O-N, which is 323 Georgia Appeal, 161, it's in Division 1. It's a 2013 case where our second highest court wrote the material requirements needed for a conspiracy under the Georgia RICO statute is for the person to knowingly and willfully join said conspiracy. There's another case called Z, like in the Honorable Lawrence Zimmerman -space, SPACE, Inc. versus Daintezjackson, DANTANNA CNN Center, LLC, and that's at 349, Georgia Appeal 248. It's a 2019 case. And what I used also was, I just looked at Donald Trump's indictment. I was interested in it.
Mm-hmm.
He is not only the former president, but the other alleged co-conspirators. They are charged several times with knowingly and intentionally joining this conspiracy. And it's not here for Mr. Williams. And mens rea is a material element of the crime and must be alleged in the indictment. That's in Eubanks, EUBANKS, versus State, which is 317 Georgia, 563. It's in Division 4. It's a 2023 case. So, you know, as you're going through this, if you're going to reconsider it, I will bring it up later, obviously, because I believe at a directed verdict motion, that would be relevant as well. But, you know, I don't know what it's like ever to be a judge. And I certainly don't know what it's like to come into a case like you're coming in. So if this helps, this is ripe under State versus Heath, Heath. Once the jury is sworn, a general demurrer can be made orally or in writing. I actually put this in writing.
Okay.
But I waited till the jury was sworn, and I did that.
Okay.
I mean, intentionally, because jeopardy attached. So.
Sure. Yeah, and if it is already in writing, I'd love to have that. And I assume this got argued at one point before if the prior judge made a ruling. So if there's a written response from the state, point me to where I can find that as well. If there's not, point me to where, like what date it's argued. I have the order, and I filed that in a motion that I gave to this honorable court. Okay. I'll get the motion, I attached it, but I didn't give you my brief. So with the court's permission, and of course the state has it already, but I'll resend it. Is it filed in the case somewhere or?
Went to the Court of Appeals.
Okay, that brief. Yeah, sure. I'll take it all.
Okay.
And then I'll assume the state filed some sort of a response, maybe not this team right here, but, and it may have been that more about that was about collateral order or not, but I'll take it and read it for whatever it's worth.
The state argued, and then they wrote the proposed order, which was signed by Judge Glanville. So, and it's a long order, it's 12 pages.
I'll take all of that.
Okay. So I thought that would be, if you grant it, it would be helpful because it would knock out all this work.
Yeah, it would. That is true.
Okay. Thank you, Your Honor.
Thank you.
I'll get you that brief.
All right. Appreciate it.
Your Honor, I'd also point the court's attention to the transcript dated December 11th, 2023. It was filed on that date.
Okay.
Of at least one of the hearings where we addressed Defendant Williams' general demurrer claims.
Okay. Is it a transcript from December 11th or was it filed on December 11th?
It was filed on December 11th. It was held on November 20th, 2023.
Okay. Thank you.
And it was specifically as to Defendant Williams' plea and bar / motion.
Great. Thank you. Appreciate that. All right. Mr. Harvey, you look like you also were maybe going to stand up and come up with something we could do. Oh, and you know what? Hang on. Sorry. If I don't do things when I think about them, sometimes they escape my mind. So I understand that for Mr. Williams, that is count 1, count 56, and count 57 you're alleging are fatally defective. And you mentioned that may be true about other defendants as well. Are there other defendants who either have already made or intend to sometime before this goes to a jury make a similar argument with regard to counts that you have against you? Oh, right. Yes, the Harvey rule. Thank you. Okay, but if you are all joining in, can you tell me, is this essentially true about every one of the gang counts that they're missing? Okay. All right. Then I can sort out for myself which ones go to which person. All right. Now, Mr. Harvey.
And this is more of an afterthought. At least I'm still having thoughts, whether they're before or after. I want to make an oral motion at this time to prohibit the state or anybody else from talking to witnesses while they're on the witness stand. Judge Glanville would give an instruction which was incorrect to witnesses. Don't talk to anybody but the parties in this case while they were on the witness stand. The only one that is, the only people that are accepted from the no talking rule once a witness is on the witness stand is a criminal defendant and the defense lawyer, because that's a Sixth Amendment impediment. The case, as I remember it, is Perry versus Leake, Perry versus Leeke. It is a United States Supreme Court case, which indicates that other than the defendant, witnesses or parties are generally prohibited from talking to witnesses once on the witness stand. So I would like an instruction. I could write this out. I can ask for an instruction.
That'd be great. I know you don't have to write out the motion. I mean, it's fine. I'll entertain it orally. And I mean, that's generally my understanding as well, but it's been a minute since I've practiced. It's been a minute since anybody raised that issue. Is there some kind of an exception for, like, I mean, I know, like, if you're on the stand and then we take a lunch break or a restroom break or something, that's one thing. Is there anything about, like, overnight that is different?
Only for the defendant.
Okay.
And the defendant's counsel. That was the whole basis of Perry versus Leake.
Right.
The state said in Perry versus Leake, hey, you can't talk to your client while he's on the witness stand. And the Supreme Court said that yes, because there were Sixth Amendment implications, that a defendant and a defense lawyer could, but generally other witnesses could not.
Okay.
So you're
Hazy
close.
memory.
Yeah.
All right. Does the state have a response?
Your Honor, I believe that the rule that Mr. Harvey is referring to essentially is the rule of sequestration, and as it relates to other witnesses and about talking about the witness on the stand's testimony. The reason I was looking feverishly is that Ms. Hilton and I had actually discussed this, and I had sent her a case, not from within Georgia, but it literally spoke directly to it. So I was at least looking for that. All right. Because I don't think that under the rule of sequestration that attorneys, I think that Judge Glanville had it right, attorneys are not prohibited from speaking to witnesses. But I want to make sure that we get the law.
Let's make sure we get it right. So I'll submit whatever you want to submit on that as well. All right. Thank y'all. We're going to take a recess right now if there's not anything we can do immediately. And we will be back at 3 on a Rule 22 matter. Y'all got that notice, right? That there was a new Rule 22 filed? Yes, Your Honor. Okay. All right.
Design, develop, scale, repeat. Wix Studio, the platform for agencies and enterprises.
One reason to try Zaxby's new chicken finger tacos? We'll give you two: Chipotle Ranch and Avocado BLT.
where's Ms. Bumpus? That's who filed the Rule 22. Good afternoon. All right, so you filed a Rule 22 at, what, 11:10 or so? That's fine. The night before last. So, and you had said that you wanted to start recording for yesterday. And honestly, I didn't even know you had filed it until we were finished with the court yesterday afternoon at 4 something, because it came in so late. And normally the Rule 22s go to our public information office, but I know about it now, and so I have provided notice to all of the parties, and I will listen now to or ask if there is objection from any of the parties or witnesses or victims to the Rule 22 filed by Ms. Bumpus. All right. So I am not real. So what are you looking to do?
Your Honor, I just want to be able to record what's going on in the courtroom.
All right. And you had already, I guess, yesterday live streamed from somebody else's
Yes.
live stream. Miss, what is that person's name?
Miss Sylvia?
Miss Sylvia?
Yeah, she's sitting in the courtroom.
Okay. All right. So there are an inordinate number of separate Rule 22s in this case anyway. I'm not really sure why everybody is not using the pooled media that is already, I mean, it's like 8 or 10 media organizations are using one pool, and then there's Miss Sylvia who has a separate one, and then lots of people who have the ability to take still photography and audio, and it's just a lot. It's like 8 or 9 different things. But I am not sure that yet another person doing essentially the same thing adds to the public's access to this proceeding. There is 24/7 coverage of this, a pooled camera, and Miss Sylvia's separate video recording that you can access anyway, apparently. So, I mean, if you want to be heard as to how that either increases the public's access or helps with the dignity of the court or the administration of justice or the truth-finding function of this proceeding, I'm willing to listen to what you have to say.
Your Honor, I'll be brief. I just would like to say that at any point, these other people who are part of this pool, they have logos, and they can pull what I am streaming on my personal YouTube and do copyright issues. They have their own logo on there. And also, I don't always want everything that they are streaming. I don't need the full court hearing all the time. There are specific parts that I need to reference and informing the public of what's going on. And that's my point of being here. And I'm just trying to do everything right so that I can, pass the smell test.
Okay. So, with regard to, I mean, obviously you can let the public know anything you want to, and you can video blog, vlog, all you want to, any kind of opinion that you want to about the case. And you can obviously also sit here and watch all of the proceedings. Are you saying that you can't use somebody else's, like the news media coverage?
It has their logo on it. At any time they can say it's copywritten and take it from me.
Okay.
From my page.
Have you asked anybody other than, is Miss Sylvia okay with you using her? Because honestly, it's a little bit disruptive to have essentially phones in court. I mean, it ought to be that unless you are somebody who has a Rule 22 already in effect, or you are an attorney in the case, you shouldn't have your phone out or on or anything. And it's kind of chaotic in this entire part of the courtroom. And I find it to be distracting. I find there to be security concerns with having to constantly figure out, okay, who's authorized to have their phone out, who is not. And so what I would like is, until there's some point when you find out that you're not able to use somebody else's, what they've already taped. I mean, I'm kind of saying, why don't you and Miss Sylvia be the second pool? Okay. Would that work?
We'll try it out.
Okay. So let's do that. Y'all are now the second pool.
You will revisit it if I have an issue.
Sure.
Thank you, Judge.
All right. Thanks. All right. Anything else we can do today? Or did I give everybody enough work that y'all can just go home and do your work? And y'all gave me plenty of work to do also. All right. So we are adjourned for the day. How about we see each other at 9 in the morning? Which doesn't mean when we get the jury back. If we get the jury back, I won't go back to 8:45. But let's see each other at 9 in the morning, and let's be ready to actually work on some actual evidence. Okay. All right.
I just want to be clear. What is your expectation of what the evidence will be?
Are we going to be able to, so y'all are getting some of the transcripts of Mr. Copeland's testimony so far. What all have we already shared? No?
It means everything to me to be.
Swimming in you, hey, little mama, said I wanna take a dip in your pool, just go for a little dive, yeah, hey, yeah, yeah, yeah. Sometimes a misty rain that gently touches my soul, feels just like fire shut up in me, yeah, simply lose control. Oh, rain down, follow me, let your love just fall like raindrops, rain, follow me. Oh, rain down, follow me, let your love just fall like raindrops, rain.